I'm going to talk to you about some laws that are specific to Colorado that may provide you as Colorado consumers with special rights and remedies in dealing with businesses, creditors, and debt collectors. So have any of these things ever happened to you? Have you ever purchased an item from a business that was advertised as new and discovered when you got it that it was actually used? Have you ever entered into some sort of a contract, like a subscription agreement, that you're told can be canceled at any time, and when you try to cancel it, you find out you're trapped because cancellation will result in a large penalty? Have you ever received harassing phone calls from debt collectors? Or been denied information about an interest rate prior to entering into a credit agreement? If you answered yes to any of these questions, which most consumers would, then you may have special rights and remedies available to you under Colorado law. There are 3 laws that I'm going to discuss today that are unique to Colorado: the Colorado Consumer Protection Act, the Colorado Uniform Consumer Credit Code, and the Colorado Fair Debt Collection Practices Act. A number of my colleagues today have discussed a variety of federal laws that may give you certain rights and provide you with certain remedies in dealing with federal agencies, but these laws are specific to Colorado and can be applied specifically to Colorado consumers. And since I am discussing 3 different laws that have different provisions, I'll just preface by saying if you have questions at any point throughout, please feel free to stop me because my conversation will kind of jump around. So, first, I'll discuss the Colorado Consumer Protection Act. The main goal of the Colorado Consumer Protection Act is preventing businesses from doing things that would mislead consumers and push them or induce them to buy certain goods, products, or services. Generally, the Act protects against a laundry list of different things that are known as deceptive trade practices. Some examples of deceptive trade practices would be advertising goods as new when they're actually used, telling you that a product contains certain ingredients when it doesn't, telling you that a product has a certain certification or is of a certain quality, and it's not. Like telling you that something is certified organic, when that's actually not true. Or failing to disclose any other important information that you as a consumer might need prior to buying that good or product. So one of the provisions of this law deals with telemarketers specifically. First, I guess the Colorado Consumer Protection Act has a lot of little laws under it that cover rights that consumers have in dealing with certain types of businesses. Just generally, it protects against those deceptive trade practices I was just discussing. But some of the laws that it contains specifically deal with auto rental contracts, timeshares, health clubs, dance studios, music advertising, ticket sales, sweepstakes, foreclosures, like my colleague just talked about. The Foreclosure Protection Act is actually part of the Colorado Consumer Protection Act, and also gift cards. And one provision that Colorado consumers find particularly interesting of the Colorado Consumer Protection Act is the Colorado No Call List Act. The #1 consumer complaint filed by Colorado consumers with the Colorado Attorney General last year was receipt of unwanted phone calls from telemarketers. How many of you receive unwanted phone calls from telemarketers? I know I do. It happens all the time. Well, prior to researching this, I didn't know that there was a way to easily make those phone calls stop. You can simply log on to coloradonocall.com, which I've provided a link to that in your materials, and you simply register your phone number with the Colorado No Call List, which was created by this Colorado Consumer Protection Act. And by doing this, it provides telemarketers with a list of phone numbers that they are prevented from contacting because they're registered with this list. So if telemarketers continue to contact you after your phone number's been added, you can file a complaint, and there's also a complaint form on coloradonocall.com or through the Attorney General's office. And you can get them to stop, and they may have to pay some sort of a penalty for continuing to call you. It may not make the calls stop immediately. It does take a few months for the list to take effect. They have to compile all the phone numbers, get them to the telemarketers, and the telemarketers update their lists periodically. So it may be 2 or even 3 months before you actually could file a complaint or before the phone calls would actually stop. And it probably won't keep politicians or charities or surveys from contacting you. But it will stop a lot of telemarketers and a lot of different businesses from being able to contact you.
I'd just like to add, that is one of the provisions of the act, is that charities, anything political, anything like that, they can call. But if you say, don't call me again, they are supposed to stop. It's not gonna stop the scammers because they don't care. But they update the list every 3 months, so 4 times a year, and it's a published time frame. So every 4 months they update the list. Every 3 months.
I'll also add, there's no charge for adding your phone number to this list. The telemarketers are actually the ones that pay the fees to run this program. Right. So it's totally free for consumers.
And you know what, she, actually Mary Sue had posted a commentary, if you go to that commentaries on the blog for the myconsumertips.info, with all of this and easily clickable and linkable and all more information on exclusions and things like that, that I found personally helpful. I went and updated and added to my, you can add your cell phone, everything, and go ahead and do that. And so it's pretty easily accessible also if you go to myconsumertips.info.
And that link's on our website also.
Yeah, okay, good.
So
and you can file a complaint. FTC, you can file, if you keep getting a scam phone call, if you can get a number, go to the FTC's website, file a complaint, because they do have a list of those kinds of numbers, and then they will attempt to go after people.
You can actually, there's also a national no-call registry, which is what's regulated by the FTC, which is a federal agency. So you can add your phone number to both of these lists, the Colorado list and the national list. So that can protect you from even more phone calls. It's just having your phone number on 2 lists that are circulated to different telemarketers. So.
Is there a period of time it's good for them?
I'm sorry, what?
Is there a period of time?
Your list, your number, once it's added to the list, it's always on the list until you remove it. You can go on there and remove it if you want, and actually there's a penalty if someone takes your phone number off of it and it's not you, they can be fined for that. So it's on there forever. Any other questions about the Colorado Consumer Protection Act, deceptive trade practices?
Is it cell phones too?
Yes, cell phones and home phones. It doesn't apply to businesses, so they can still contact businesses. The second act I'm going to talk about today is called the Colorado Uniform Consumer Credit Code. So a number of the other laws that are being discussed today that deal with credit cards in the credit industry are federal laws. But this is actually a Colorado-specific law that deals with consumer credit. So what is consumer credit? These would be loans or lines of credit that you take out for personal, household, or family uses that are typically less than $75,000. So if you're taking out a business loan, it's probably not going to apply to that. This is just for consumer credit. It also has to be done by someone who regularly issues credit. So if you borrow money, take out a loan from a friend of yours or a family member, it's probably not going to be covered by the provisions of this. So they probably won't have to comply with all the things I'm going to discuss.
If you have a big family, everything's
So the main protections provided to Colorado consumers under the Uniform Consumer Credit Code is, 1, a right to get information. You as a consumer have a right to information before you enter into a loan or credit agreement. They have to tell you what fees you're going to be charged and what interest rates you'll be charged. You can ask questions and they have to give you that information prior to entering into the agreement. It also prevents credit issuers from charging you unreasonable interest rates. So they can't charge you some crazy fee every month for allowing a balance to roll over. Also, if you're late in making a payment 1 time per year, because everyone makes mistakes, sometimes you might just miss the deadline. The creditor that's issued you that credit has to inform you that you have 20 days to pay that, as well as any late fees that may apply before having other penalties applied to you. It's called a right to cure, and you get 20 days. You also can cancel certain contracts that you enter into under this law. So if someone comes to your door and sells you a loan or a credit card, as a Colorado consumer under this law, you get 3 days to cancel it. You can say, sorry, never mind, I don't want to do that, within 3 days, and they have to leave you alone. And the biggest thing that I think is important for consumers to know under the Uniform Consumer Credit Code is that it protects you from abusive and harassing collection practices from creditors. So if you're late in making payments, which again, everyone makes mistakes and it can happen, there are extenuating circumstances and you may not be able to pay your loan payments or your credit card on time. So if that happens and a creditor is seeking payment from you for the amounts that you owe, they can't do things like call you multiple times per day or in the middle of the night. They can't use profane language on the phone. They can't threaten to use force against you. They can't threaten to disclose that information that you owe money to third parties to keep that confidential. And they also, yeah, that's mostly it. But there are other things that they can't do, specifically if you feel like you've been harassed by a creditor. And again, this is a creditor, someone who you've directly borrowed money from that's coming after you to pay it back. Then if they're harassing you, they probably are prevented from doing so under this act. Yes.
Now, would that be by mail also, or just phone?
Yes, mail also, but typically the more complaints that are received are them contacting you over the phone all the time in the middle of the night. So if they do contact you by mail, they can't like make it public on the outside of an envelope or send you postcards about having to pay back certain amounts.
And it may depend on the content of the letter. For
Yeah.
example, like if they said you're going to get from jail, or like
Yeah.
tried to make it look like it was coming from a law enforcement agency when it really wasn't. I mean, that's what we hear about is harassment.
And you can stipulate within the argument word, right? You can stipulate no word.
Yes, you can. And there's actually another law that I'm about to talk about. Once your debt gets turned over to debt collection or a collection agency, which is a third party collecting on your debt. Again, this is just applicable to creditors, who's the person you borrowed it from and you're paying them back and they're asking you about it. That's what this applies to. But once it gets turned over to debt collection or a collection agency, there are a number of other provisions that might protect you as a Colorado consumer. Yes, ma'am.
I just want to add one thing. If you buy a car, you do not have 3-day right to rescind. A lot of people call our office and they say, I just bought a car on Saturday, I want to take it back, but they're saying no. You do not have 3-day right to rescind an automobile sale. The only time you have that is if they have a car show like down in Denver and you purchase the car at the car show away from their dealership, you have 3-day right to rescind, but you do not have 3-day right to rescind on car deals.
In California, they have, where you pay $200, I think it is, that, if you return that car within, 24 hours or 3 days, I think max, you are charged that $200. You have to
That's
pay
California,
Yeah.
that's not Colorado.
Yeah, right, but I'm just saying that's something that, they offer there, the cooling off period, but usually there's no cooling off period.
And again, like I discussed with the Colorado Consumer Protection Act, there are a lot of different provisions that apply to specific businesses or specific contracts you may enter into. And there are several Colorado laws that apply specifically to sales of automobiles. So you may have different rights under those different laws. I'm just giving kind of a general overview of these 3 big laws. There's a lot of information about those different types of transactions on the Colorado Attorney General's website, and I've also provided a link to, it's called the National Consumer Protection Week website, it's ncpw.org, and if you're looking into purchasing a vehicle, used or new, anything like that, or getting a health club membership, a specific type of transaction, you may have special rights available to you under Colorado law. So you could look into that and see what your rights are, but there are a lot of them and they're very technical. So I would suggest you do a little research.
Yeah, because the point was really good. Thank you on the cars, because that's one of those odd. It's really interesting, actually. It's kind of funny because you have to really look at the particular thing. It's like difference for health clubs, difference for if you buy a diamond ring at a jewelry store in a mall. I mean, there are like, if she says no law, I'm serious. Like there are like weird
Weird stuff.
sort of
Or some you buy siding for your house And they do it at your house.
Right, and
Then-
I actually had
Right.
some guy come to me, like, at my door and try to, like, hotbox me into buying siding, because it's supposedly falling off my house, and I'm laughing because I sort of was playing him, because I wanted to see what he would all say to me, on how many illegal things I could sort of rack up before I said, I'm a consumer protection attorney. He laughed.
Did he walk or run?
He kind of ran, and he wanted to get out of the neighborhood, because I said, I really hope you're not talking to any of my neighbors, and he was like, I'm done.
And so just to clarify on that 3-day cooling off period I discussed, that's just specific to consumer credit transactions is what I was referring to. So if someone does come to your door and they try to sell you a loan, they say, I'm going to just give you this loan and here's your fees, whatever, you have 3 days to say, never mind, I don't want it under that law. But there are a number of other cooling off periods like we discussed for different transactions. So the third law I'm going to talk about is the Colorado Fair Debt Collection Practices Act. So like I discussed before, creditors may come after you directly to collect on amounts that you owe on a loan or credit card agreement or some other sort of debt that you've incurred. However, after a certain amount of time, they can also turn it over to a third-party debt collector, which may be an attorney or some other person, or a collection agency. And once that debt is turned over to a debt collector or collection agency, they're the one that's contacting you, trying to seek repayment that they're then going to give to the creditor. So this protects this law specifically protects Colorado consumers from unfair, abusive, or harassing practices from those third-party debt collectors and collection agencies. So the two main things that this law protects against, although debt collectors can do anything legal to collect money that you rightfully owe, it does prevent them from making public the fact that you owe a debt and you're being contacted by debt collectors. And it also prevents them from engaging in harassing or abusive practices, some of those that I discussed earlier relating to creditors. So generally, they have to keep all communications between you and the debt collector confidential. They can't go out and ask other people that you know about debt. They can't go tell them that you owe debt and you're being contacted by a debt collector. If they're sending you things in the mail, it can't be a postcard that says, I'm a debt collector and I'm seeking repayment of this debt from you. It can't be a letter that identifies on the outside of it that it's a debt collector contacting you. They have to keep all of that information confidential. They also can't threaten you that they're going to disclose that information to third parties because they're not legally allowed to do so. There are a number of other abusive and harassing practices. Some of those I discussed earlier, like using profane language, calling you in the middle of the night. They actually, under this law, can't call you before 8 o'clock in the morning or after 9 p.m. If they call you during those hours, they're in violation of this law. You can file a complaint. So there are a lot of little things that they can't do. Make any sort of false representations to you about what might happen if you don't pay it back. Say that they're a law enforcement agency when they're not. They can't do anything deceptive in trying to collect that debt from you. They also, within the first 5 days of contacting you, they have to provide you, as the debtor, the consumer, with notice of what the amount you owe is and who you owe it to. They have to tell you who your creditor is and how much you owe. And once you receive that 5-day notice, you have 30 days to dispute the debt. So say you're contacted by a debt collector and you don't remember buying something from this person. You don't remember taking out that loan. You don't think that that's you. You don't think that that's right. You have 30 days to dispute that debt. If you fail to dispute it within 30 days, then the debt is considered valid. But once you dispute it, they have to look into the loan and verify, or the debt that you owe, and verify that it's actually you and you actually owe it. And if that's the case, then you will have to pay it back. But they can't turn that information over to your credit report as undisputed debt if you do dispute it within those 30 days. You can also cease communications entirely with a debt collector under this law. If you don't want to deal with a debt collector anymore, say you know that you owe the money, you're just tired of them calling you, you don't want to deal with them, you can make a written request and say, please don't contact me anymore, and completely stop communications. But if you do owe the money, they may be able to sue you or collect on it somehow. But if you just want to stop dealing with them, you do have that right under Colorado law. You You can also limit the times of day they can call you. You can tell them, don't call me at work, or don't call me on my home phone. You can only contact me on my cell phone. You just have to make those requests in writing to the debt collector or collection agency. So what can you do about this? The remedies can get complicated under the different laws. Like we've already discussed, there can be specific provisions that may apply to certain transactions, but generally as a Colorado consumer, for violations of these laws, there are 4 different things you can do. 1, file a complaint. You can file a complaint with the Colorado Attorney General's office, also with the Boulder District Attorney's office, as we learned earlier today. They have both of those offices may have the ability to handle these complaints. It just depends on where the business that you're complaining about is located and things like that. So you could even file a complaint with both offices to be safe and ensure a quick response. You may also be able to file a claim in small claims court. Under these Colorado laws, you as a consumer can actually recover the damages or like whatever money you lose because of one of these violations. You as a consumer may be able to recover that money. If it's less than $7,500, you could probably handle it in small claims court. But if you think the amount that you were damaged is more than that, you may want to seek an attorney's help and file a regular lawsuit. There are different provisions under these different laws that allow consumers to actually sue the business that harmed them. For example, under the Colorado Consumer Protection Act, you can actually sue a business that engaged in deceptive trade practices if you feel you were injured by those practices. But again, it can get really complicated, and I would definitely advise seeking the help of an attorney before you think about doing that.
Also,
Yes.
there's the state runs a debt collection agency, and you can file, if you find that they're in violation of collecting a debt, you can file a complaint with them. That's all they deal with is debt collection agencies.
Okay. There's information about all of these different laws and the different complaint forms are available on the Colorado Attorney General's website. So that's a good starting place, and it can link you to these different agencies and different people that may handle the specific complaints. I've provided a link to that as well, to the File a Consumer Complaint page on the Attorney General's website, and it lists all the different types of complaints you can make. And the easiest thing to do is probably just to pursue remedies through some informal mechanism, like calling the business. If you buy something because you think you're getting one thing and it shows up and it's something totally different, before you start filing lawsuits or filing complaints, you may just want to call them and they'll say, oh, sorry, our mistake, refund you your money and let you send it back. That may not always happen, which is why it's important to know these rights, but a lot of times you can get these things taken care of really easily before you even get to that point. The biggest thing you can do is protect yourself. Do your research before you buy a product or service. Insist on seeing it before you pay for it. Ask lots of questions before you take out a loan or enter into a credit card agreement. Keep copies of any payments that you make, receipts you make for payments if you're dealing with a creditor or debt collector, and also keep track of the times of day that they're contacting you and the methods that they're contacting you through. So that in the event you do feel you've been violated by one of these laws, you have a paper trail and you can provide the appropriate enforcement agency with that information so that they can stop them from doing this to you and other consumers. So here's all the links I was talking about earlier. Any questions?
I had a question about it. You're talking about this is Colorado. What if you order something online like Amazon?
It's
Where
if you
different
live here
law.
and you have a complaint about I don't care where the company is, but if you live here, you can call our office. We can deal with the same with the Attorney General. As long as you are a resident of Colorado, if the company is outside of Colorado and they're trying to collect a debt, doesn't matter. They have to obey Colorado law.
Okay, great.
Because they've chosen to do business.
Right.
Okay.
So
want
they
your
have to,
money, so
they have
they
to
gotta
follow our
follow
laws.
One thing though to know, if you are dealing with an online company like Amazon, and one of my colleagues is going to talk about this later, there may be something in the contracts that you know how you click I agree and stuff online when you buy something. There may be things in some of those contracts that might prevent you from availing yourself of these remedies, but generally, yeah, if you live in Colorado and a business has harmed you, they have to comply with this.
And I just want to highlight, thank you, because the thing is, I really hope, and feel free free to ask us questions, but I'm glad we started out the day talking about the squeaky wheel and just talking about, consumer complaints. Because the bottom line is that there's a lot of ways that you can empower yourself and not sort of give up easily. And there's so many different ways you have to cast a wide net. And of course, time value, they're all busy and everything else, that usually the informal mechanisms are gonna be, your best bet. And the DA's office is fabulous, because they're local versus federal is gonna be more difficult and time lag in terms of actually getting a response. But again, I think we as consumers really can be empowered and by using our own voices and making those, there's so many different ways that you can sort of protect yourself, and I think that's really an important takeaway on a lot of these. And hopefully a lot of these links you can see all the different ways that you're able to do that. And again, just as everybody's talked about, keeping paper copies. Yeah, you're really mad because you got this horrible letter in the mail and it's just unfair about debt collection, says you're going to jail, whatever else, and you want to rip it up and yell tons of expletives and walk away. No, keep it.
Keep it.
And don't be throwing that away. I don't care as much as you want to trash it.
And once you have a problem, keep a copy of everything you send to the company, and I know it costs money, but send it return receipt requested so that you have, or it's certified, so you have proof that you sent it. And so if in case it ever goes to court, you could say, no, I sent it, here's my receipt.
Super important. Another thing that I found to be incredibly important that's easy not to do is when you're hitting, let's say you're doing this by email or online, you hit send it, but you didn't print it first. Print, keep a copy, print, hit print,
BCC yourself constantly.
I always CC myself and I print. Or
Lines,
actually, or either way, but definitely still that paper copy, because you never know what's going to happen to that computer, the computer system, all the rest of it. But I think it's really wise. Put a paper clip, keep it together, have it ready. I think these are all really important things in order to cover yourself, because it's really sad later on when you're like, oh, I wish I kept that, and you're looking all over the house for it, all over the everywhere for it, and it's nowhere to be found. And so then you just walk away from something where you really do have rights.
And they do on the consumer complaints on the Attorney General's website, it does ask you to upload any documents you may have relating to the complaint you're making. And the more documentation you have and can provide them, the more likely they're going to be able to enforce the laws against that business or debt collector or whatever. So the more likely you're going to actually get some sort of a response from them if you provide them with this information. So it's really important to keep it. Any other questions?
If you have a medical debt and you've been paying them every month, but you're not able to pay it off, do they have a right to call you if you've been making a payment every month?
Depends, but if you're in default, they would. And actually they'll send you letters and things, and they do if you're in default, but it depends. Are you on a payment plan and you're making those payments? Then no, you're not in default. But I will say that if you are in default, generally speaking, what I've found out just through my own research recently, and it depends on the particular hospital or the particular provider, but after about 90 days is usually when they'll send it to a collections agency. And so once it goes there, then but you do still have those rights.
But even if you're paying the money.
But if you're paying it, then no, because you're not in default. Again, you have to look in the terms and conditions. If you're paying less than, that's what I'm
If you haven't
asking.
made a payment plan and you're paying less than what you're actually supposed to pay per month, they will.
And to explain the word default, because when I use that, what I mean is whatever the terms are. Let's say that you talk to the hospital or you talk to the provider and you say, here's our plan.
I have insurance, and it was just the portion that wasn't even,
Oh, that's
you know,
we'll have to
covered
talk at
by
the break.
insurance.
We'll have
yeah.
to talk at the break, because that's a whole other issue that I've actually just recently researched, so we can talk about that.
Okay,
But that's a
great.
different
Thank
thing, because it may be that the insurance company is dragging their heels and not sending it in, and it puts you in a tailspin of calling everybody to get up and call work documents. A terrible situation for consumers. It actually makes me really mad, but it is what is happening right now.
Great. Any other